Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Today's question comes from a listing broker who explains that he has a big problem. The transaction has closed, and prior to closing, the seller did a fair amount of work on the property, had hired several contractors to do an extensive amount of work on the property. And now seller's gone, and those contractors haven't been paid. The listing broker makes clear in the question asked that while he gave the referral to contractors, he did not call the contractors, he didn't order the work to be done, he didn't oversee the work to be done, he never signed a contract with the contractors. Everything was handled by the seller except for the referral made by the listing broker to the seller. Nevertheless, now that the seller can't be found, the contractors are coming to the listing broker asking for payment. And the question from the listing broker is, do I have any liability to these contractors? Do I have an obligation to pay the contractors? And the answer is very simple. Absolutely not. Listing brokers, and this is really a message to buyer brokers. And the question is actually much larger than the question as it was presented. Because what I often hear through hotline questions is that the buyer had, and this question, of course, dealt with contractors who are looking for payment. We don't have an unhappy buyer necessarily, although if there are liens filed against the property, we're going to have an unhappy buyer. Different situation. But in many cases, we do have an unhappy buyer. Seller failed to get all of their junk out of the property, and buyer had a big expense in hauling away a bunch of garbage. Seller failed to clean the property. Buyer had to hire a cleaning team to come in and clean the property before they could move in. Seller failed to make some repair that buyer thought they had made, or that seller had represented to buyer that they had made, and they didn't discover that there was a problem until they got in. Seller was obligated to leave the washer and dryer, but didn't, took it with them, and buyer discovered when they moved into the property that the washer and dryer was gone. And in so many of these questions that I hear on the hotline, it's the buyer broker charging the listing broker with an obligation to fulfill the contract obligations owed by whom? Owed by the seller. The purchase and sale agreement is a contract between the buyer and the seller. And so when seller promises to remove their garbage from the property, to clean the property, to leave the washer and dryer, whatever the problem might be, seller may have breached the contract with buyer. And in this case, it sounds like seller breached contracts with contractors who did work on seller's home. But the listing broker is not responsible for fulfilling seller's contractual obligations. So why do I say this is a message to buyer brokers? Clearly, listing brokers, you need to know that you're not liable. And so with this video, I hope that you know that. But it's a message to buyer brokers because buyer brokers, you need to be careful of what you tell your buyers. It seems that too often the buyer broker is the person who suggests to the buyer that the listing broker should be liable for seller's breach of contract. Buyer brokers don't create that impression in your buyer's mind. You do a number of things that are problematic. You create a false impression in the buyer's mind that they've got a source for recovery. They don't. Listing broker's not a source for recovery of the seller's breach. You put the listing broker in a terrible position of having to defend something that they didn't do wrong. You create a situation where the buyer may be going after the wrong party for recovery. Buyer needs to be going to their lawyer and talking to their lawyer about a recovery claim against the seller. And then one more issue that we probably don't talk enough about in our industry, and buyer brokers pointing the finger at listing broker, that's just one example of this bigger problem. The bigger problem is within our industry, we have a problem right now of being very, very confrontational to one another. Our industry is built on cooperation. That's what the MLS is all about. Cooperating brokers, helping buyers and sellers get to the common goal of purchasing seller's property. It's an industry that is, in fact, built on cooperation, but what we're seeing more and more is a degradation of our industry culture resulting in this terrible, bitter fighting between brokers in a transaction. And what happens when brokers go at each other in a transaction? unquestionably that spills over to the clients. And now all of a sudden, buyers hate sellers because of conversation that pits brokers against one another. So buyer brokers, when you tell your buyer that that listing broker is liable for seller's breach of contract, you create in the buyer's mind this impression that listing broker did something wrong. And you create this confrontational approach between the buyer, the consumer, towards one of our industry members when it's wholly misplaced. Listing broker did nothing wrong. Seller is the person who breached the contract, and that's where buyer needs to be directed. There's any number of problems that result from a buyer believing they have a claim against a listing broker when the seller is the party who engaged in the breach of contract, and if there's a claim to be made, it's from buyer directly to seller. Buyer brokers, the best thing you can do for your buyer in this situation is advise that buyer to seek legal counsel. Listing broker, all you can do for the contractors in this scenario is advise them to seek legal counsel. Whatever the source of the complaint that's described in this video, the seller is the party who breached a contract, and any claims asserted need to be asserted against the seller. Listing broker didn't breach the contract. If you have questions about this topic or any other, send an email to me, legalhotline@warealtor.org.